good. Welcome, everybody. My name is Marty Mascari. I am a contractor with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC, both of which are under the umbrella of the North Central Texas Council of Governments in the greater Dallas-Fort Worth, Texas area. Today, I'm actually traveling to a conference in Austin, but I usually live in the just north of Frisco in the Dallas-Fort Worth area. And that's where we usually join you from, or host from, I should say. So we're blessed here today to have Francis Espinoza, our partner at the North Texas Fair Housing Center, to talk about tenants' rights, security deposits, repairs, late fees, and more. All the we see lots of issues with people with these with any one of these things, and so we're going to cover these more in depth today. So before we get started, if you could advance to slide 1, Francis, and I'll talk to you about, there we go. We're going to talk about CEUs. For those of you joining us today that are looking for certificates of attendance or CEUs, we're providing CEUs for licensed social workers and licensed professional counselors that are licensed in the state of Texas. I've had people get their certificates before from various seminars, tell me they've been able to use them for other licenses inside or even outside of Texas. But just so you know, there's no guarantee because I'm only set up with these two jurisdictions. We're also provide a certificate of attendance if you'd like one. The guidelines for both of these are the same. One thing I will say is that please listen carefully, because the CEU process is different from many of our webinars because they're different CEU providers. So what we may ask of you for this webinar may vary from what we may have asked you last week to do for a CEU. And I know people get confused because they start just thinking all of them are the same, and they're not all the same. We have different CEU providers depending on the presentation. So today's webinar is worth 1.5 hours of CEU credits. You must complete the entire live webinar and the Q&A in order to be eligible. You must complete the Google evaluation survey. This should pop up or give you an option to go to it as you close out of Zoom. It is embedded in Zoom. But if it doesn't, and I realize some companies have blocks on pop-ups, then you will also receive that in an email from me, in a follow-up email from me, that link along with the slides, the link to access the slides and that type of thing. So the Google survey will be up till the 5th of October. And then please give me about a month. I'm fairly behind right now. We're at the end of our contract years, and so there's a lot of other things that I had to get in before the end of the contract year. So I'm a little bit behind right now. But if you give me a month, we should be able to have those out by the sometime in October. So I'm going to turn it over to Francis Espinoza. She is the executive director of the North Texas Fair Housing Center, and she's going to talk to us today about the tenants' rights. Francis, it's all yours.
Thank you, Marty. Is my volume okay?
Yes, it's great.
Okay, cool. Okay, so Marty already introduced me, so I'm just going to get started. If you have questions during the presentation, please type them into the chat, and if we have time at the end, we'll look through the chat and try to answer as many questions as we can. Okay, so I wanted to just generally talk about leases to start with, and a lease is a binding contract. So I think sometimes because it's housing related, people don't see it as an actual contract, but legally it's a contract that binds you to a certain term. Typically that's going to be 12 months, but it could range. Some apartments offer, or some rentals offer less than that, or some even offer up to 18 months. Don't sign the lease. This is a big thing that happened, we get a lot of calls on this issue. People who go see a rental, it's not in the condition they'd like it to be in, but the person that is leasing it tells them that all those things are going to be taken care of before they move in. come move-in day, they realize they go to the apartment and see that none of it's been done, or they go to the rental and see nothing's been done. And so, if at all possible, don't sign. If there are things to be done, don't sign a lease on the promise that it's going to be, things will be fixed or repaired or cleaned. Make sure that stuff is done and it's in the condition that you want to rent it. It's in the best condition. Okay, so I wanted to show you all a sample of a lease. And this is the Texas Apartment Association's lease. This is what most housing in Texas, most rental housing will use the TAA lease. It actually gets updated once a year, but sometimes rental will be using like an outdated form. And there usually aren't too many things that change year to year unless a law changes, which just, so everybody realizes that Texas is very biased towards landlords. And so there aren't a whole lot of laws in Texas that are protective of tenants. And so, from year to year, not a whole lot changes with the lease document. Okay, so let's talk about security deposits. So the security deposits should be clearly listed in your lease. And when you move out, the housing provider has 30 days from the date you move out to either return the deposit or send you an itemized list of what they use the deposit for, or a combination of the two. So say, for example, your deposit was $500. If they use $250 for different repairs or cleaning, they need to give you a letter that says that's what they use that for, and then refund the rest. And you have to leave a forwarding address for the clock to start ticking. So make sure that you do that. We do have some clients who do not want to leave a forwarding address. And if that's the case, you could always give me a call and use North Texas Fair Housing Center to receive your deposit back. The check, of course, would be made out to you. And once we receive it, we can let you know and you could pick it up. Okay, so this is typically what a lease will have in it for the security deposit. So I just wanted to show you what this language would look like in a lease. So it talks about the refund policies and what they can use it for and things like that. So one really big thing to be aware of is returning your keys. And so I know I just said, 30 days from the date you move out, you leave a forwarding address, and you move out, and 30 days after you move out, they have that amount of time and the clock starts ticking when you leave them a forwarding address. But one important thing to realize is that at that time that you move out, you have to return the keys. If you don't return the keys, they'll assume that you're still renting it or you're still in the property. And so if you don't return the keys, they might add additional charges of daily rent. And two, you're not technically moved out without returning the keys. So that 30 days that they have to return the deposit hasn't started yet. Okay, so let's talk now about repairs. So the landlord, and there should be sections in your lease that talk about repairs. So the landlord is supposed to make repairs, or if it's an apartment, the management staff is supposed to schedule repairs. And typically now there's a portal that you would go to, sign in, and do your repair request. If at all possible, print out a copy of that repair request for your own records. Or you can actually just take a screenshot once you've submitted it to show that you did your repair request, just so you have documentation for your own files. And generally speaking, repairs are really, it says 7 days, which is, that's on average, but it really depends on the repair. And so, if it's a non-working toilet and you only have one bathroom in your rental, then that's probably going to be more urgent than if you have 2 bathrooms and one is still working. If it's a burst pipe, of course, that's an emergency and should be dealt with right away. A leaky faucet, maybe like the 7 days is fine for a leaky faucet. So a really important thing to know is that you should always pay your rent regardless of whether or not the property management or owner is doing the repairs. I can't tell you how many tenants contact us and they have decided that because, their last 5 requests for repairs have been ignored, and there's some things in the apartment that are, in their opinion, problematic and should have been remedied already, they on their own decide not to pay rent. And you never want to do that. You want to keep making your repair requests, but you always want to pay your rent. And the way the example I use to tenants is, or to renters is, the roof could be caving in on you and you still have to pay your rent. So just be aware of that. There's really never a good way to, there's really not ever a reason to withhold your rent. And if you've caused, as the renter, if you've caused the need for the repair, then you might be, if the lease says it, you might get sent a separate bill for that repair. So you might be expected to pay for it if you caused it. I've seen leases before that have addendums about plumbing, and if the tenant has caused the problem, then they have to pay for it. So the maintenance staff of the apartment will probably still fix it, or they'll call in a plumber to fix it. But the tenant will be billed separately for that because they caused the issue. So when you do a repair request letter, make sure that you detail what needs to be done, sign it, and keep a copy for your records, and send it by certified mail so you have proof of when it's received. This whole issue of sending it by certified mail, because a lot of apartments do things electronically now over the portal. Like I said, if you do a repair request on the portal, just, take a photo of it, or if there's a way that you can, get a copy of that emailed to your own email address or anything like that, you want to make sure that you do that. And this is just an example of a really simple repair request if you have to do one on your own. So just send it, address it to whoever's in charge of getting those repairs scheduled. Put your name on it, your address, and then the detail what the repair is. Sign it. And then, you can fill in the bottom part if you're sending it by certified mail, which you should, because you want to have proof that you notified the rental or the owner that this repair needed to be made. Okay, so what are the tenant's remedies for landlord's failure to repair? So, the terminate the lease or sue. A lot of leases have language in it that if the repairs aren't made, that's considered a breach of the lease or breach of the contract by the owner. And I would recommend that even if that provision exists in your lease, not to use it, because, if it doesn't define exactly what that breach would be, courts almost never side with the tenant on these issues. So they don't side with the tenant on, the landlord breached the lease issues. So the other thing that tenants can do is, if you're stay in the rental, continue paying rent, and you could actually sue the housing provider for not providing you with a habitable place to live. And you can quantify that and take your lawsuit to Justice of the Peace Court, which is the small claims court for Texas. They call it Justice of the Peace Court. And if you can quantify what your damages are, you can sue. So an example would be 1 month's rent plus $500, or actual damages if your things were destroyed because of what happened in the apartment, or make sure you include in there any court costs that you've had to pay to file the claim. And if you hire an attorney, you can ask for your attorney's fees. And you can also ask for part of your rent back for the days that the repair wasn't made. If the rental wasn't habitable, and say for example, you had to stay at a hotel, you can ask for reimbursement of those costs. So, people contact us all the time and ask about, what's the procedure for repair and deduct? And that's never recommended. We don't recommend it. Legal aid doesn't recommend it. Even the Texas Bar Association, their handbook on tenants' rights, they don't recommend it either. And the reason is that the process is so complicated and has so many requirements that if you just miss one thing, you haven't followed it properly, and so you won't win on that issue of legitimately deducting any repair costs from your rent. So that's never recommended. Okay, let's talk about late fees. So late fees is one of the issues that surprisingly the Texas legislature actually did in 2019 clarify, because late fees were kind of all over the place with what management companies or rentals would charge people. So these fees should be outlined in your lease, and don't assume that you have a grace period to pay your rent unless it says that in your lease, because some leases say it's due on the 1st, and after that there's a late fee. Some will give you until the 3rd to pay, and then the late fees accrue. So just make sure that you read your lease and you're aware of whatever their policy is for when you start having to pay late fees. And in 2019, the Texas legislature passed a property code that now gives guidance on what the maximum late fee can be. So for buildings of 4 units or less, the late fee can't exceed 12% of the rent. And for buildings with more than 4 units, which is, I think probably most multifamily housing in Texas has way over 4 units. So a late fee cannot exceed 10% of the rent. And we still get calls from people who have been charged outside of these laws, and their landlord is trying to charge them a lot more than these. And so, having this property code, bringing this property code to the attention of your landlord would be helpful. So, like I said, surprisingly, that's a law that was recently passed. Okay, so so the lease language would say something like this: if we don't receive your monthly base rent in full when it's due, you must pay late fees as outlined in the lease. And so this little section in red, that's what it's going to look like. It'll have an initial late fee or a daily late fee after a certain number of days. And see at the bottom of that box, if you don't pay by the 3rd, then you're going to have to pay a late fee. So this is from the TAA lease. So typically the TAA leases will give you a grace period between the 1st and the 3rd, but always do check that to make sure that you're following what the lease says. Okay, let's talk about utilities. So most apartments don't include utilities in your monthly rent. There's either separate charges that are itemized each month and given to the tenant, or they're charges that you pay directly by placing utilities in your name. So, some of the older apartment buildings might have only one electric meter. And so electricity would be one of those bills that's just apportioned across the board to tenants. But the newer properties the newer ones have meters for each unit. And so you actually have to put the utility in your own name. So there's a couple of ways. If there is only that one meter and the apartment is apportioning the cost across all tenants, they can do it a couple of ways. and it's something, once they decide a way to do it, they should really stick with that way. But they could give you a notice, a 30-day notice, that they're going to change that. But these are the two typical ways that they'll do it. They'll either do it by the number of tenants per unit and divide it that way, or which is more common, is they'll apportion it by the number of bedrooms. So 2-bedroom units will have to pay more in, say, a shared electric bill than a 1-bedroom unit. Okay, so you should see something like this in your lease, where there's all these different categories, and then they put in there if there's a flat fee that they're going to charge you. Like, for example, look at trash service on the right side of the screen. If your apartment has a valet trash service, they may charge you like 10, 15 bucks a month, 20 bucks a month to come. Like, usually they designate a couple of days a week that they pick up trash, and you have to set your trash outside your apartment, and they come and pick it up. And typically when there is that kind of fee, there's no way around it. So even if you say, well, I don't have a problem bringing my own trash to the dumpster, that may not be an option. And even though you are physically able to do that, you still have to pay this service fee if they have it in your lease. So, it's a good idea to try to look for this section in your lease, so that you know what you're going to be charged for. One of the interesting things here is that, you see animal rent. I think I'm going to talk about that a little bit later, but, some apartments will charge, if you have a pet, they'll charge you pet rent, and that'll be added to the monthly rental amount every month. Or, they might just charge a pet deposit, or they could charge both. Some apartments now, I think, have doggy poop cleaning service, and they apportion that across the tenants that have pets, and so you'll have to pay for that too. Okay, let's talk about transfer fees. So if you want to move to another unit in your same apartment building, you typically are going to be charged a transfer fee, and those fees should be listed in the lease. However, if you transfer because you need to transfer due to a disability, you can request a reasonable accommodation to be exempt from that transfer fee. Okay, here we are with pets. So your lease will state, and there'll be a section, and most commonly there's going to be what they call a pet addendum, so that they can gather more information about your pets. And it'll state whether you have to pay just a pet deposit, or pet deposit and pet rent, or just pet rent. If you have an emotional support animal or a service animal, you can request a reasonable accommodation to be exempt from both pet deposit and monthly recurring pet rent. Oops. Okay. Pest control is another one of those things where if they have a set amount of a set fee per month that you have to pay for pest control, really there's no way around that either. And what they do is kind of apportion pest control services across the entirety of the tenants. And that means that, you'll get this service, and it might be, once a month, every other month, really depends on how they schedule it. But the fee that you're paying per month is so that you get that pest control service. So typically it's going to be included as a monthly fee in your lease. Sometimes they'll also offer additional pest control services when the pest control person comes out. If you want additional services, you can pay for those separately. And be aware too that a lot of leases now are coming with specifically bed bug addendums, because it's been such a problem that's kind of grown in the last 5 years or so, that apartments are now trying to pass that cost on to tenants. So if you have bed bugs, you might have to pay the pest control to remedy that. And if they blame you for bed bugs going to other adjoining units, you might be required to pay for that pest control too. So be aware and make sure that you read if they have a policy specifically for bed bugs. Rental insurance. So some apartments or some rentals require the tenant have rental insurance, and that's legal for them to require that. Some don't, some recommend it, but just be aware if they require it, you're going to have to show proof that you have your own rental insurance policy. And if you don't, they might require that you pay a company that they work with for your rent insurance. So they might get it for you and just add it into your lease. So make sure that you're aware of that. And it's good to have rental insurance if you're worried about your belongings, because it'll cover your belongings if they're destroyed by, say, a flood in your apartment, or if somebody breaks into your apartment and steals your things. So the renter's insurance only covers your property in the unit. The apartment should have their own policy for the actual building. Now, parking can be a really difficult issue because there are so many things regarding parking that you need to make sure that you're aware of. So if the lease should have a section to talk about parking, because there are a lot of different ways that rentals deal with parking. Sometimes it's a monthly fee that you pay to get a space assigned to you. Sometimes there is just a space assigned to a specific unit. And so it comes with the apartment. Or sometimes it's just a big parking structure, and parking is kind of first come, first serve. You'll get whatever space you get based on, when you go in and out every day, I guess. So, just be aware of that. And sometimes there'll even be a difference between covered parking and non-covered parking. So I've seen, places that have, if you want the uncovered parking, it's kind of a free-for-all. If you want covered space, then you could pay a fee every month and you get a covered space reserved for you. Same with garages. Like sometimes apartment buildings will not have a garage for every single unit, but they have some garages, and tenants can rent those at a separate fee per month and have their own garage. So there's so many different scenarios for parking. Just make sure you're aware of that, and also make sure that you review the section about towing, and when they are make sure you're aware of what they state in the lease, that they have when they have the right to tow your car, so that you don't violate any rules and then come out one day and your car's gone. Because unless you can show that they towed your car wrongly, you're going to be on the hook for the towing fee and to get your car back from wherever it was taken. So just, and those are things that, if you feel like it was done wrongfully and they won't give you your money back, you would have to take them to small claims court or justice of the peace court to try to get your money back. And, you'll hear me say justice of the peace court a lot during this presentation, because Texas doesn't have a lot of laws regarding the landlord-tenant relationship. Tenants are left with, if you want to enforce your rights, you have to go to justice of the peace court. Or if you want to get your money back, you have to go to justice of the peace court. And that's just, the way it is in Texas. If you want to enforce a lot of tenants' rights, if you want to enforce them, you have to go to court, justice of the peace court. And understand too that, we're in Texas, very pro landlord, pro property owner state, as are a lot of the judges that are appointed by the politicians that feel that property rights supersede everything. And so, judges aren't necessarily going to decide in your favor, even if all the evidence is on your side. So just be aware of that so that you don't feel like, there's not an easy answer to a lot of these landlord tenant issues in Texas. Okay. Entry into your unit. I think a lot of people aren't aware that in Texas, they don't have to, housing provider does not have to give you any notice to enter your unit. They can just enter the unit and, if you ask them to give you notice, they may give you notice, but they don't have to. And they can even enter your unit when you're not home. So just be aware of that, because that, the way this issue comes up a lot is when folks call us because they're renting a single family home. And for whatever reason, the owner has decided now they want to sell. And so they need to do showings, right? And so, tenants always tell us that, they don't want anybody in the house, or they want to be notified, well in advance. And, those may not be options. So just be aware of that. And, look in your lease and see if it has any notice requirements in it. Typically they don't, but maybe there's something in there. And like I said, you can ask to get notice, like for, please give me 24-hour notice or whatever, but sometimes they won't do that because a lot of people want arrange same day viewings. And so you won't be able to get that kind of notice. So just be aware of that. But like I said, it mostly comes into play when you're renting a single family home. Okay. All leases will have provisions in them if you want to terminate them early. That's never recommended, because in order to legally terminate your lease early, you are required to pay whatever fees are outlined in the lease. So there'll be, typically there'll be the penalty for terminating early, and that could be equal to 1 month's rent or 2 months rent. And then you might also be charged a reletting fee, which can be like a kind of a make ready fee. And they justify that, like they have to clean the apartment or whatever for the next person. And that might be, I don't know, $100, $150. If your housing provider agrees to let you out of your lease early, get that in writing, because I can't tell you how many people, they get upset about something. Maybe it's repairs that weren't made, or some other dispute with either the housing provider or with another tenant. And so, they angrily go to the rental office and they tell the manager, I want to terminate my lease. And the manager will say something like, go ahead, you can leave whenever you want. Okay, that is not really permission to move out. And so what'll happen in that case is they'll go after the tenant, most likely, for all these fees, and it'll appear on your credit report. So just be really careful. A verbal, yeah, go ahead and move out, or you can move out whenever you want to, is not an exemption from paying all of these penalties for moving out before the lease term is up. So if your housing provider agrees to let you do that, you have to get it in writing. And tenants will go back and say, well, can you put that in writing, after they talk to us? And the housing provider's like, no. If you want out of your, and then it'll come up, if you want to get out of your lease, you have to pay all these fees. So just be aware of that. There's really only two legal ways to terminate your lease early without any fees or penalties in Texas. And one is under the Fair Housing Act for people with disabilities who have to terminate their lease early because of their disability. But in a lot of cases, when the tenant's trying to do it on their own, the housing provider will not approve it. And so, that's the time to give us a call, because the tenant really needs an advocate to make sure the housing provider knows what the law is. And the other reason is if you're a victim of domestic violence, and there are some requirements in both the Texas Property Code and under VAWA that you can, requirements that you can meet in order to terminate your lease early without any fees or penalties. I just had a client actually Monday, finally got the housing provider to agree to let her out of her lease. She was a person with a disability, and her apartment, she lived on the 5th floor, and her apartment had 2 elevators, but they were never working. They were almost always out of order in both of them. It wasn't like they made sure if one was out of order, the other one was working. There were many times when both were not working for long periods of time. And so she finally got tired of it and was like, I need to move to someplace that I don't, because, it was almost impossible for her to go up and down 5 flights of stairs. And so, her mom had asked for the accommodation to terminate her lease early without fees or penalties, and they denied it. And they came back with, saying, well, the fee to terminate your lease early, it was something like $4,200. And they said, well, because she has a disability, we'll charge her half. And so they cut that in half, which is, not what they're supposed to do. They're supposed to just let the person terminate early without any fees or penalties. And, if it's, she wanted to move at the end of September, and, that's going to be, this end of this week. So, it would have been reasonable for them. I didn't give them this information, but, it would have been reasonable for them to ask for at least 30 days notice if they wanted to. But, we didn't offer that. And we said, I told them she wanted to terminate at the end of September. And, I emailed back and forth with the manager, who initially was trying not to budge, and said that she, had already made this offer of half the penalty for her to move out early. And I was like, well, and then, I gave her all my spiel about the Fair Housing Act and, early termination and everything. And finally on Monday, they sent me an email agreeing to let her out September 30th without fees or penalties. So, sometimes, even if the law is on your side, you can ask for something and the housing provider will push back because they think they can, or they want to take advantage of a tenant, or, they don't want to lose any money. And so, that's the time to get an advocate involved, to help you out. And this is what the section for early termination in a lease will look like. And so it'll itemize what you have to pay if you terminate your lease before it ends. And so just, be aware of that with your lease document. And I had talked about a reletting charge. So the slide before was the early termination penalty. And then here's the reletting charge, which and this is from the TAA lease, a reletting fee charge of, and they fill it in, not to exceed 85% of the highest monthly rent during the lease term. So, that could be quite another bit of money. That could be another chunk of money if you have to pay reletting fee and the penalty for leaving early. Okay. The end of your lease term. So landlord and tenant both have the right to end their lease, to not renew their lease. And so make sure you review your lease and that you have a reminder that you have to give note. If you're not going to renew, you have to give notice within the time frame that the lease states. And sometimes it's 30 days notice before the lease ends, and sometimes it's 60 days. Like I said, both tenant and landlord can decide they don't want to renew. And I get calls all the time from tenants that are very upset that they were told their lease is not going to be renewed. But on the landlord's side, they have discretion to decide whether or not they want to renew, and they can decide not to renew and not give you any reason at all. That's their right in Texas. So there's no absolute right to have your lease renewed unless you live in public housing. Public housing plays by different rules, in that if you have to have committed some breach of the lease, and it's specific breaches, not all types of breaches, but specific ones that would allow a housing provider not to renew. But in regular market rate housing provider can decide, we're not going to renew your lease, and not give you any reason at all. So just be aware that just be aware of the amount of the amount of days notice you need to give. Because say you have to give 60 days and you decide you don't want to renew your lease, but it's only 30 days to the end of your lease, they can require you to stay another 30 days to make the 60 days, meaning you would go 1 month over your lease term. And during that 1 month, you may be able to pay the same rent that's in your lease. But if they give you a 30-day notice that your rent will increase or your rent will change, you might have to pay more that last month. So, but they have to give you the 30 days notice. So if it's less than 30 days, they can't charge you an increased amount, or they're not supposed to. Okay, so here's the section where, so this is language from a lease, and it'll say a minimum of X days written notice to terminate your lease. And so, they'll fill in 30 days or 60 days in that item. Okay, so when you move out, you can request that they do a walkthrough with you, that property management does a walkthrough with you, but it's not required. So legally, you don't have a right to get that. So if they tell you they're not going to give you, if they tell you they're not going to do a walkthrough with you, you really can't force them to. So one of the things that we recommend is before you move into a rental, take photos of everything. And then after you've moved all your stuff out at the end, take pictures of everything. So you have before and after photos, and those will come in handy if you do not get your deposit back and you feel that it was like they wrongly kept your deposit. Those pictures are going to be your evidence to show that you left the rental in a good state, in good condition. Okay, so I think we have some time to do a quiz before we do questions. So type your answers in the chat. So which of the following is not recommended when requesting repairs? There may be more than one answer. So what's not recommended? To be current on the rent, to send a letter with a traceable form of delivery, withhold rent until repairs are made, a notice signed by the tenant. So which one is not recommended? What do y'all think? Yes, I see everyone typing C. Yes, that's correct. So it's never recommended to withhold your rent until repairs are made. The other A, B, and D are things, yes, you should do if you're doing repair requests. Okay. Which of the following is an example of acceptable rental practices? There may be more than one answer. So here we're looking for what's acceptable. The landlord allows a tenant with a disability to transfer as long as they pay a $500 transfer fee. B, the landlord charges a move-in deposit and a monthly fee for pets. C, a tenant is experiencing pest problems and decides to withhold rent until the landlord addresses the issue. Or D, an apartment requires you to have your own account set up with outside companies for water, gas, and electric. So which of these is an example of an acceptable practice? So what are people putting in the chat? Oh, good. People are putting more than one because there's more than one answer. So what's acceptable? B is acceptable. The landlord can charge a move-in deposit and a monthly fee for pets. And D, they can require you, if they have separate meters, to set up your utilities with outside companies and put them in your own name. Okay, C, we talked about never withhold your rent. And A, if you have a disability, you have to make that request, but you should be exempt from a transfer fee. Okay, another one where we're looking for an example of acceptable rental practices. So what's acceptable? The unit a tenant is going to rent is occupied. The landlord shows a model bedroom and is exactly like the unit, so the tenant signs the lease. B, the landlord wants to implement a late fee of 15% of the rent when leases expire. C, tenant is asked to pay an additional admin fee after the lease has been signed. And D, the landlord allows a tenant to move out before the lease term expires, but charges them a fee for reletting. So what's acceptable here? Okay, so let's go through these really quick. A, that actually is an acceptable practice, and it happens all the time where you'll be shown a model unit instead of the one you want to lease. So although acceptable for us, not recommended, it's better if you see the actual unit you're going to rent because you could see what condition it's in. What about B? So when we talked about late fees in an earlier slide, 15%, was 15% one of the percentages they could charge you? No. So that's not acceptable. It can't just be a flat 15%. I think, what was it, 10 and 12, I think. C, tenant is asked to pay an additional admin fee after the lease has been signed. No, that's not acceptable. If they're going to charge an admin fee, that should be an admin fee they pay that you are told about before you even sign the lease. And then landlord allows a tenant to move out before the lease term expires, but charges them a fee for reletting. That, yes, that's completely acceptable. Okay, one more about what is acceptable. The landlord advises that they will take care of the move-out inspection and the tenant does not need to be present. B, the landlord keeps the entirety of a tenant's security deposit. C, a tenant has asked the landlord for repeated repairs during their stay. The landlord decides not to renew their lease at the end of its term. D, the maintenance team does a planned safety inspection of a unit while the tenant is not present. So what's acceptable here? Okay, so these, we'll go over these one by one because they're a little tricky too. So A, the landlord advises that they will take care of the move-out inspection and the tenant does not need to be present. There's nothing illegal about that. It's just something we recommend that you don't do. That if they're going to do a move-out inspection anyway, that they allow, you ask to be present. What about B? The landlord keeps the entirety of a tenant security deposit. That could be okay, depending on why they're keeping it. And as long as they give an itemization within 30 days to the tenant of what they used it for. They can't just decide arbitrarily we're going to keep it. They have to follow the law and let the tenant know this is why we're keeping it. We had to pay for, this repair, that repair, and a cleaning. C, a tenant has asked the landlord for repeated repairs. The landlord decides not to renew their lease. That's not acceptable. That's retaliation. And if you, just because you've asked for repairs, that's not a reason that they shouldn't renew your lease. But it's very hard. That's going to be a very hard case to bring, for example. So it's going to be hard to prove that unless they tell you that's why they're not renewing, which they won't because they know it's retaliation. It's going to be hard to prove that that is the specific reason they didn't renew your lease. But, that's not something that they should be doing. It's not legal. And then D, the maintenance team does a planned safety inspection of a unit while the tenant is not present. Yes, that is acceptable because like I said before, the tenant does not have an absolute right to be told if the housing provider is going to enter their unit. Okay, so make sure you protect yourself and read through your lease document before you sign it. And ask questions. Don't feel bad about asking questions. If you have questions about any individual item, you can ask about it. if you wanted to call us about something that you found in your lease that you don't like, or, don't understand, you can give us a call. And if you have if you feel in your gut that there's some problems or you have some concerns, don't sign it. And then you can contact us with any questions that you have. So I think we have some time, a little bit of time for questions, right, Marty?
Yes, we do. We have lots of time. We actually have 35 minutes if we need it. But I'm gonna, if we could, yeah, go ahead and look through the questions, and let's do that first, because since we have a lot of time, we'll go over the CEU stuff after a bit.
Okay. Yeah, just let me know when I need to stop with the
Yeah, no
questions.
problem. No
Okay.
problem. We got a long way.
So somebody asked, he kept my deposit with a lie, I can prove it was a lie, and threw me out because I'm disabled and I'm considered lower class to them. Okay, so you have at least a year to take them to small claim justice of the peace court. So from the time you move out, you have a year to go to file a claim in JP court to get your deposit back. If you have, evidence to show that they shouldn't have kept your deposit. And, there's an additional portion to that security deposit law that I didn't talk about, which is, say 30 days has already passed and the housing provider doesn't give you anything. No itemization of what they've spent the deposit on and doesn't refund the deposit. The law states that if you take them to JP court, you could actually ask for 3 times your deposit amount in damages. And that's because they didn't follow the rule of the 30 days to get you the itemization, a refund, or a combination of the two. So, that's kind of what if you feel they wrongly kept your deposit, small claims court or justice of the peace court is what you need, is where you can find a remedy, hopefully. Okay, another question, and that was from Kimberly Mullins, who had 3 different things, but I think I addressed them. So Kimberly, if I didn't address everything, you can email me, and we can talk more offline. So, oops, somebody asked, what happens if landlord sells the house before the lease is up? They still need to give you some notice, but, essentially, like I had said before, there's not really, when the landlord breaches the lease, there's not really a whole lot a tenant can do about it. So, hopefully if they sell it before the lease is up, they'll give you 30 days notice. But again, if you feel that having to move out before your lease was up due to no fault of your own, and you can quantify some damages of how that affected you, monetary damages, then you could take the owner to small claims court or justice of the peace court to try to get that money back. So, possibly moving expenses, or if you had to miss days of work because you had to move sooner than you thought, things like that. Like, you just have to put a dollar amount on what you're asking for, and your only remedy for that would be justice of the peace court. So
can I ask you a question about that?
Sure.
In regards to that, if the landlord sold the property, would you suggest that when they go to justice of the peace, they sue the person they signed the lease with along with the new owners? Because doesn't sometimes the lease obligation transfer with the property?
Typically that only happens when it's multifamily housing. So if it's a single family home, it's a little bit different. And I don't know that those transfer. So
I guess my point being is if you went to court and the old landlord, or the person you signed the lease with, were to bring as their defense, well, I don't own the property, they didn't keep, they're the ones who didn't, keep the obligation. In other words,
yeah, I mean, I think it's probably better to sign the to sue the person that you signed the lease with, which
Okay.
would be the person who sold it.
Okay.
Um, just because a lot of times with single family homes, there'll be requirements in the purchase documents that it has to be vacant.
Uh,
Like most often they most often that's what happens. And it's not like multifamily housing, like the new owner doesn't want to inherit the tenant and there's no transfer there. So it's also the person you signed it with that breached the lease. So that would probably be your best bet,
okay.
unless and I don't know how a tenant would find this out, but unless that your lease was supposed to be transferred to the new owner until it was up.
Yes, and I guess that's the reason why I was thinking that you should go to sue both of them when you go to small claims court, because then they have to prove that, right? Because then they could say it. They could say, well, it's the other person's responsibility, not mine. But if they were both a party to the lawsuit, they wouldn't they have to document who or to
Yeah, then
defend.
they have the person, if one of them isn't at fault, they could
Yeah,
show documentation to that. But yeah, that you can bring them both. You can sue both of them.
and that gets very complicated. No, I was just curious. Go ahead. I'm sorry.
Oh no, that's okay. Let's see. This is a question for you, Marty. Will we be able to rewatch the Zoom meeting recording?
Yes, yes, we record the webinars. We do not record the clinics that we do with the Fair Housing Center, just because we don't want people to be intimidated to come and ask their very personal questions in the clinic. But the webinars we do record, and those will go up on our YouTube channel, and we will send out a link to everyone that registered for this in a second follow-up email.
Okay, good. Does Texas have any laws against monopolizing when it comes to utilities? I have seen where you have to sign up for service under Spectrum and it's not negotiable. Not, I think, in monopolizing in the sense that you're talking about, no, there's no law against it. A housing provider can just decide that they're going with a specific company and that's going to be the company that services their apartment building. So, I think it's more typical that if you want services like cable, for example, or you pick your own and it goes into your own name. With the newer properties, that's the case, and also with electricity, because they have separate meters, you could put it in your own name. But I don't think monopolizing in the sense that you're talking about has any bearing on whether the apartment uses their discretion to go with a single company and you have no choice. Because the thing is, like, you don't have to rent there, right? You can go somewhere else if you don't like it. And you probably would find out, and that's another reason you probably would find out what utilities are offered before you sign a lease. But that's one of the reasons why you do want to make sure, because if you have some issue with Spectrum and you just don't want to ever use their service again, and this property only uses Spectrum, then maybe that isn't something that maybe you just don't want to live there. So let's see. Next question. What if your dog is an ESA, but one of the breeds the renter restricts? Okay, so is there a way to try to apply anyways? So with emotional support animals, it's a little bit hard. Housing providers might have discretion to not allow certain breeds. And one of the reasons is that emotional support animals, they're not certified or trained to do anything, nor do they have to be. And so, the housing provider's argument is, well, if you're needing this dog for emotional support, why does it have to be a pit bull? Why can't it be a poodle, for example? And so, when you go to a place and you have an ESA, an emotional support animal, and you find that out, you may not be able to fight it. You might just have to find another place to live that will accept your breed of dog. The only thing that you might be able to do, and I think you probably should, at this point, contact an advocate, is, we've made the argument before that if somebody has had the dog for any length of time, they've already, emotionally bonded with the dog. So to ask them to get rid of it, or, to get another breed, just would exacerbate the symptoms of their disability. But that's not an ideal case to make, because we get a lot of pushback from housing provider in those cases. So just be aware of that. That would be the only way around that, and it might not work. So if you have an emotional support animal, put that out there at the very beginning before you even pay an application fee at an apartment, because you want to know, do they have any issues with that? You also want to make your accommodation request, before you sign the lease, so that there's not problems after you sign the lease. Next question, dishwasher has a large amount of dark water sitting at the bottom, maintenance request submitted 3 different times. None of the repairs have fixed the issue. If you've made numerous requests to repair and they're just not working, you could ask them to replace the appliance. They don't have to, and they may not agree to do it. So just be aware of that. But, this is the issue, that your question is a difficult one, because they're trying to fix it because they don't want to buy a new one. So they keep trying to fix it. So it sounds like they're, trying to do their due diligence and repair it. It's just, in this case, it's probably just not going to work. But, you might end up having to deal with constant repairs if they're unwilling to replace it. But, it doesn't hurt to ask if they will replace it. So next question, as it relates to pest control, if you have an infestation, who pays for the additional house visits? So, typically, if you have an infestation and they already have pest control service, and that, you might pay a set amount every month for that, then the additional visits should be covered by the fee you're already paying. So you shouldn't have to pay, especially unless it's a problem you caused, like say roaches. If it's a roach infestation, they should keep paying, it should be under their service plan with their provider, that they do numerous visits to remedy the problem. If you caused it in some way, like maybe you just moved in and you brought the roaches with you and your stuff that you packed, they might have an argument for you making those payments for additional visits. So it really depends on the situation. Next question.
Francis,
Yes.
I'm going to ask one there's a whole bunch of them in the chat. I'm going to start trading off with you if I could.
Sure.
Is that right? Melissa asks, should the tenant expect to sign a receipt for the keys when they return them? Go ahead.
No, they typically won't give you a receipt. You can ask for one though, but there's no requirement that they have to give you a receipt. And don't ever leave the keys in like a drop box or anything like that, because then they could say they didn't get them. So you want to hand them to somebody to make sure that they have received the keys. But like I said, it doesn't hurt. There's no requirement that they have to give you a receipt, but it doesn't hurt to ask for one.
But she said should the tenant expect? But I don't think the tenant would be expected. But surely it's ideal if you can get them to give one from the landlord to you, so you have documentation
Yes.
for the keys, right? Yeah.
Right.
Okay, I'm sorry. Go ahead. You can go to the next.
But don't expect, tenants don't expect to get a receipt for that, because that isn't typical. But like I said, it doesn't hurt to ask. Renters, somebody has a question about renter's insurance. It looks like I have renter's insurance, but I am still charged a monthly damage fee from the apartment. Is this normal? I've never heard of that before. So that might be something that we can talk more about offline. And I'd want to see your lease where it says that there's this damage fee, because I have never heard of that before. Okay, if they have it in the lease that they give 24-hour notice, can you hold them to that? Yes. If it's in your lease contract, then yes. you can hold them to that 24-hour notice because they're the ones who put it in the lease. And then if you both signed off on it, then that's the rule. So, outside of, like I said, there's no absolute right to get notice before a landlord enters your unit. But, the parties can agree to another rule, right? So in this case, if in your lease it says 24-hour notice, then they should be giving you that. Did you have one, Marty?
I have one. I'm assuming that it said, does this apply to homes to the percentage? And I'm assuming they're talking about the percentage of late fee for the late fee. And I think they're asking, does that apply to single family homes that you'll
Yes,
be
it,
permitting
it
as well?
applies. Yeah. Yes, it applies to all rentals. So with a single family home, it's the rule with 4 or less units. So, I mean, that's most typically if it's 4, that's going to fall in that one under the one rule, 4 units or less.
Yeah.
Unless, the person you're renting from owns a bunch of properties and you can show that they own a bunch of properties, then you might be able to hold them to the other rule of the 4 units or more.
There you go. I'll ask another one here real quick. If the tenant is approved for an emotional support animal from a doctor after they've moved in, can the landlord refuse to accommodate?
No, they shouldn't be refusing to accommodate. So I would want to know why they're refusing to
Yeah.
accommodate, because if it's one of those breed issues, that's something that you have to work around. But that's why, we recommend for folks to make that accommodation request before you move in. And you can supply your doctor's note because housing provider has a right to request the doctor's note. But if you're already moved in and you do that later, it's not ideal, but I'm assuming you moved in and then got the pet or got the ESA. So if that's the issue, even in that scenario, if you're already moved into a place, before you get the ESA, if at all possible, make the request and go through that process first before you bring the ESA into the household. I know that isn't how things work most of the time. Somebody will get the ESA and then make the request. So, but still it can't be denied. But again, it shouldn't be denied. Legally it shouldn't be denied. But, I would want to know the reason they're denying it for, because, like I said, there might be something that, like a breed issue that they're denying it for. And so then you have to work around that.
And that would be definitely something that you would want to contact Francis' office about if you're in our service area, right, Francis?
Yes, definitely.
That is definitely what they do in regards
Yeah,
to.
because I'd want to get more information in that situation.
Okay, go ahead.
Um, I have a question. When you say they can enter without notice, do they have to have a reason to enter, like to respond to a repair request? Or can they just enter randomly without a specific reason? No, they should have a reason. They're not supposed to enter just randomly. I mean, they don't have to give you notice, but there has to be a reason that they're going in. I mean, it could be a repair. It could be, a simple thing like just changing like a filter in an HVAC unit, or changing a light bulb or whatever. So, um,
And and for those of you that aren't
you know,
familiar with it, an HVAC unit is an air conditioning heating unit.
yeah, and they shouldn't just be randomly, like there's no reason for, there's no, you have a right to privacy. Like there's no random check. There shouldn't be any random checks. Okay, if an apartment complex provides parking, hold on.
I'm sorry.
The question
I
just
just moved it
disappeared.
up. Sorry. I'm trying to clean them out while after you finish it. But go ahead.
Oh, okay. If the apartment complex provides parking and assigns one spot per unit, then later after signing the lease, mandates a new rule of charging $5 for guests to use parking spots. Is this legal? How can one fight this? Okay, so this isn't really about parking for tenants. This is about guests. And so, leases typically have provisions for guests because they'll have like a guest policy that guests can't stay over 5 days or over 7 days or over 10 days. And a $5 parking fee for a guest is not illegal, but they should have given you some notice of it by either putting it in the lease or if it wasn't in the lease and they're going to add this as a new rule, they distribute the new rule to all the tenants and give 30 days for it to be effective so that they're giving you proper notice. So, when you say, is there any way to fight this? I think that would be really difficult, but I would want to know, was it already in the lease or is it just a brand new rule? Because, on its face, charging $5 for guests, I've never seen that before, but it's not illegal.
This was okay. So Samsung asked, she was wondering about if the landlord becomes difficult to contact. In other words, they're not in the office, they don't return their calls, they don't respond to emails. Is there something they can do about that?
Not really. I mean, unresponsive landlords or managers or management, there's really not a whole lot a tenant can do about that. I mean, continue to abide by your lease, and maybe you consider, if that's not a place you want to live, that you give notice and move after your lease is up. But yeah, there's nothing really you can do to force them to respond to you. You can send letters certified if it's a repair issue or something like that, but in that situation, I'd want to know, like, what is it that the tenant needs a response on? Are they not making repairs? Or is it just kind of an owner or a manager that's MIA just because they're too busy or, aren't giving it any time?
Yeah. And Samsung, she asked about contacting us. First of all, there'll be a contact information to Francis, both at the end of this, but also in the follow-up email I send out. But this isn't one of those things that there's anything they can do about. The landlord.
No, there really isn't anything they can do about it. I mean, there's nothing I could do about it. I can't force them. I can't force them to respond to you either,
Yeah.
So if a private owner is placing your home on the market prior to renewal of your lease, do you have to let strangers in your home while you aren't there? Is it legal to leave a key box on your door for strangers to enter without the landlord being present? So yes, unless there's a different rule in your lease that states, if this home is put up for sale, we have to give you X amount of notice to have people enter. They don't have to give you any notice, and they can just put a lockbox on the front door and, set up appointments for visitation. Realtors can set up appointments to go visit it. So yeah, that's kind of where you're at, unless your lease specifically states that they have to give you some type of notice before they show a home for sale.
But it is in the lease that it is in a lot of leases that they have the right to show it if they decide to sell it or towards the end of your lease term to release it. Isn't that correct?
Yeah, I mean, typically there'll be something in there if it's a single family home, and they might, if they're already thinking about selling it, there might be something in there that, if we decide to put the home on the market, we're going to be showing it. And, typically there isn't a notice requirement in there that they have to abide by. So, I mean, it's unfortunate for tenants, but, just know that going in, that if you rent a single family home, if it is something that your landlord hasn't rented for very long, they might decide that it's not for them and they want to sell it. If it's if it's a single family home that's been rented for years and years and years, then that probably is more safe to say it's not going to be put on the market. But things change for folks, and it's their right to put it on the market, right?
I'm going to struggle through this one real quick, but it's a question about rental insurance, and she's asking about a surcharge, paying for a rental insurance surcharge of $6, which covers the structure of the building. Is this legal? I filed a complaint with the Department of Insurance, and they agreed with me that I should not have to pay it. it's she's already paying $21 in rental insurance, but I don't know
Yeah.
if it's $6 in it or out. But go ahead.
So this sounds like a situation where the housing provider is passing on their own insurance costs to tenants. And that's not, I'm surprised the Department of Insurance said they shouldn't be doing that because there's nothing illegal about it. They can charge, housing providers are now passing on more and more costs to the tenants. And so, especially in this housing market that we're having, and because they can get away with it. And so, they can decide like, we want all the tenants to pay for the building insurance and we'll just divide it across our 100 tenants or whatever they have. And they could charge you for that insurance policy, a monthly fee. That's
Yeah.
no different because, it's insuring the property. It's kind of not different than apportioning you a piece of the electricity.
Yeah.
Because, in that scenario with the electricity, if they only have 1 meter and they're apportioning it to everyone, you're probably also paying for the common area lighting, which isn't in your apartment. It's in the courtyard and the laundry room or in the, by the mailboxes.
In the parking lot.
So, and we're seeing this more and more. I can't remember. There was I recently saw a really interestingly named fee that was being charged to tenants, and I can't remember what it was. What was it, a luxury fee or it was for some sort of like services, but it was a little bit odd to me. But they can make up fees and charge you. I mean, unless you can show that it's not related to something. And with this one, it probably is their building. It probably is the structure policy for the building. So it's not like it's not a real cost. You know what I mean?
Yeah. Yeah, and it's gonna sooner or later it's gonna be like hotels where you show up and not only you pay the overnight, but now all of a sudden you have to pay a resort fee on top of the rental and they require it for every night you stay there kind of thing. You know what I mean? They're gonna
Yeah,
make us pay for the pools.
and you know what, Marty? I know this resort fee, apartments are now charging something like that. It's for the same type of thing, but they're calling it something different. I just can't remember right now.
I haven't seen it yet, but yeah, it
Because
doesn't surprise me.
there's a gym in the building and there's also a pool. They call it something and they now are charging because they have to pay somebody to maintain the pool, right?
Yeah, and they're just passing. They used to just absorb those costs in the rent. Now they're passing them on as additional costs.
And the more they can separate out different charges that they or different bills that they pay or fees that they pay in a month, they can pass those on to tenants.
Yeah.
I wouldn't be surprised if eventually you saw like property tax fees being sent over to renters. That might be that might not be okay, but so I have a question. Do you have to pay to complete the lease terms for additional months if you pay the reletting fee, i.e., if you want a term early and pay the reletting fee, are you still on the hook for the remaining months? So you should not be on the hook for the remaining months, but it's more than a reletting fee that you have to pay. There's two different things you have to pay. One is the reletting fee and the other one is the penalty. So typically it's not just going to be one fee. There's going to be a penalty and then the reletting fee. And if you pay those, because one of them is going to be 1 or 2 months rent and the equivalent, in the lease provision I showed you on the slide, it said the reletting fee couldn't be, I think, more than 85% of the highest month's rent. But there's an additional fee for leaving early, and that could be 1 month's rent. It could be equal to 2 months rent. And if you pay all those fees, then no, you shouldn't be on the hook. But just keep in mind, it's going to be more than the reletting fee. Can you explain sorry, go ahead.
Is the landlord obligated to discuss tenant dispute accommodations with a housing advocate?
Wait, what? Say that again.
Is a landlord obligated to discuss tenant disputes and accommodations with a housing advocate? If the tenant goes to somebody to advocate for them.
Yeah, but some will require that they get permission from the tenant. I mean, if you're asked, if an advocate is involved, I'm assuming the tenant brought the advocate in and it's okay with them for the landlord, for the, housing provider to talk to them. But, I experience pretty often, it's probably like 50-50 where, in 50% of the cases, they'll just talk to me, the housing provider will. But then, the rest, I call them and they're like, we can't discuss a tenant with you without permission. And then I have to have the tenant either email them permission, or, get on the phone with us and do a 3-way call. So, you know,
Um,
I hope, I hope that answered the
yeah,
question.
I think you did. Um,
Can you all explain or expound on pest control issues as it relates to rodents, and the tenant's contribution to the problem? So, I know I used roaches as an example earlier. Now, rodents are a whole different thing. And rodents, you can actually call code enforcement or the health department to come and cite for rodents. And then, then the issue is the place so, is the rental so dilapidated that it's just a problem in the whole building that there are rodents, or did the tenant somehow contribute to it by maybe having a hoarding issue? And so, that's a difficult one because I would want to or need to get more information from, the landlord or the tenant to find out, what is the situation. Because I've seen it caused by the tenant because, there wasn't a rodent issue until, years after the tenant moved in and they started hoarding things and it just became an issue. But I've also seen where housing is in such a bad condition that there are rodents now coming into the property. And so I would want to know what kind of the basis of it was.
I'm going to ask this one, and then we'll go to the CEU slide if we could after we finish this next one, and then we can do more if you want to do it afterwards. But we're getting close to that end.
Okay.
So does everyone in the housing units have to have the same terms in their contract?
Typically, yes. The only thing that might be different is obviously rental charges, because rental charges change with the times. And so, I've seen situations where incoming tenants are charged actually less than tenants who live there or just moved in because, the rental market has changed. That also could affect the amount of deposit that people leave. So those might be different. But as far as like, how utilities are apportioned and rules related to parking and things like that, those are typically going to be the same across the board.
But now, the one thing you got to remember, I think that's important to point out too, about is, landlords are going to change their lease format from time to time, and obviously, they might start using it on people after you signed, and you won't see it until the next time you renew your lease, kind of thing.
Right. And fees might be different because, people have different lease renewal dates. And maybe when you moved in this month and now the fee for, trash service is $20 a month, but your neighbor is paying only 15. But what'll happen is if they get their lease renewed, they'll probably go up to the $20 a month.
Okay, so for those of you joining us today for CEU credits, today's webinar was worth 1.5 hours of CEU credits for licensed social workers and licensed professional counselors in the state of Texas. That's who we're set up with. Just to make a note that we've had people go through the process, get the certificates, and use them for other licenses, but there's no guarantee. And those licenses could be other licenses in Texas or licenses outside of Texas, but that would be at your own risk. But you're more than welcome to go through the process, get your certificate, and submit it and see what they do. We're also providing a certificate of attendance if you'd like one. The guidelines are the same to get either one. In order to get either of these, you must have completed the entire webinar and the Q&A. You must complete, now when I say the Q&A until we get to 11:30, which is in a minute. But once we get past that, and if Francis has time and wants to stay and answer questions, and you want to stay on, that's great. But if you don't have to stay on, obviously we're past the end time of the webinar. So you must have attended the entire webinar during the time we've advertised. You must complete the Google evaluation. Google evaluation should give you the opportunity to access it as you pop out as a pop-up when you go out of Zoom today. But if it doesn't, fear not, you will receive that link in a follow-up email from me, probably tomorrow, in a follow-up email that goes out. I'm leaving here to go to a conference as soon as I'm done here. And then the Google evaluation survey will be up till the October 5th at 5 p.m. And then give us about 4 weeks after that to get the certificates out to you. And if you don't have them by then, feel free to give me a call. So Francis, go ahead and will you advance the slide one more, please? Let's talk about next month's topic. So next month's topic, we're going to do self-help tools for tenants, and we're going to talk about template letters, unethical landlords, landlord versus tenant scenarios, and when should you get an attorney involved. And so that's our next month on October 25th. Please help us spread the word for that. And then Francis, I don't know if you need to go or you want to stay and answer a few more of the questions.
Oh yeah, I can stay and answer some questions.
Okay, super.
Okay, so I think this is the next one. What if lease expires but landlord doesn't give written extension but gave verbal okay? What happens when he wants to end the lease? So if they don't give you a written extension, meaning a new lease document, you're month to month, which means on a month to month, you only need to be given 30 days notice that it's going to end, and they can give it to you anytime. And that's, that's the one positive thing for tenants, right? When they sign a lease, it's for 12 months where they can't change your rent and they can't, you're bound to it. But if they say it's going to continue, but they don't give you officially a new document for a lease, then technically you're month to month.
And month to month would be under the same terms and conditions as the written lease, except for it's 30 days at a time under the same rent, right?
Right. And if they wanted to increase the rent, they should give you a 30-day notice that that's going to happen. They can't just, I can't tell you today that I'm going to increase your rent October 1st because I'm only giving you like a week notice. So if I want to tell you today that the rent is increasing, then really I shouldn't implement that until November 1st.
The other thing is that it also, that month to month also puts you in a position too where you only have to give the landlord a 30-day notice to leave as well, as long as you're only month to month.
Right, exactly.
But you still have to give them a 30-day notice to move out, just like you would have, just like they would have to give it to you.
Yes. So somebody asked, legally, does the landlord have to show you the breakdown or explain what the admin fee for 150 covers? I'm assuming this admin fee is going to be the one you pay when you first go to a place to rent. You're a new tenant. And no, they don't have to. They typically just call it an admin fee, but it should be reasonably related to something. And so you could ask for a breakdown, but they don't have to give you anything.
Here's a question. Does everyone in a housing unit have to? Oh, I already asked it. I'm sorry. Go ahead.
Oh, okay. Can you ask them to pay court costs as well? Yes. If you're going to take your landlord to Justice of the Peace Court, you can not only ask for court. Well, I'm assuming court costs would be like a filing fee. You can ask for that back. Plus, if you, are able to hire an attorney, you can ask for their fees back as well.
Can the landlord state that the security deposit is non-refundable?
No, not they can have like for a pet deposit, they can say, half is non-refundable and half is refundable. But for your regular lease, they can't say it's not refundable. They have to abide by the same, security deposit rules that the state has. which is, 30 days to either give you an itemization of what they used it for or give you the deposit back. However, if it's in the lease that it's non-refundable, and you decide to sign it and agree to that, then yes. So landlords and tenants can always agree to different terms as long as they both sign off on it. I feel like all my questions just disappeared.
Okay, so no, we're getting down to the end. I see what's on
Oh,
your
okay.
screen.
Oh, okay.
We're
I was
getting
like,
down
what
to the end
happened?
of the question, but there's some in the chat still. But are electrical issues wiring considered an emergency repair issue when the landlord has been notified, but no action has been made?
Yeah, I mean, it really depends on what kind of electrical issue. Like, do you have live wires that are not attached to anything? Or is it just maybe an outlet that isn't working or a light switch that isn't working? As far as, when they should be dealing with it and whether or not it's an emergency really depends on the facts, and it depends on the situation. So if it, for example, is those live wires that are not connected to anything and they're a hazard, that's a situation where you could call your city's code compliance department and ask them to come inspect, and they should go out there inspect, and they should give a citation to the housing provider to fix it, and a timeline for when that should happen. But if it's just like an outlet that isn't working, that's probably not going to be an emergency.
If there's smoke coming out of it, then it is, right?
Yeah,
I mean,
exactly.
I think reasonably, if there's a reason, to believe that there's imminent danger, then I think it's important, that you
Yeah, and
have
if there's a
considered that.
live wire, yeah, and if there's a live wire
Yeah,
anywhere, go to your breaker box and see if you could turn off the one that feeds that particular wire so that it's not live.
yeah. Um, what if the landlord of the house of the rent house dies, or the owner of the rent house, I guess?
So the tenant, if they're under a lease, that lease is still binding. And hopefully somebody who's gonna, take it over, inherit the house or whatever, will contact the tenant. If the tenant doesn't know who to pay their rent to, um, I would still set aside the rent until you find out who you're going to have to pay, so that, set it aside so you make sure not to spend it so it's available. But, if the person who dies has a spouse, talk to them about how to pay the rent after that. But, whoever takes over, whoever from the family inherits the house, inherits the lease in that case. So, the lease is still binding.
Would you continue to, like, if you were paying by check? And I know a lot of ways we don't do that anymore, but if you're paying by check, would you go ahead and still write the check to the landlord and mail it, or do whatever you used to do just to make sure you have proof that you continue to pay?
Yeah, but I would try at least, before, try before paying it to find out if you should be making it out to someone else. But if you can't, then yeah, I would do that and deliver it to make sure that you could prove that you paid.
Hmm. Is it as a private owner, is it legal for them to have a no pet rule? Well, go ahead.
Yeah, no pet rules are legal, but there has to be, the housing provider has to provide an accommodation if the person is a person with a disability that needs a service animal or an emotional support animal.
Yeah, yeah. So
Um,
just because they would have to provide you an accommodation, that's just a way of an accommodation, so you don't, so around the rule. But they have no pet policies anyway, right?
yeah, there's nothing wrong with no pet policies. They're completely legal. But even in those situations, a person is allowed to request an accommodation if they have a disability.
and the landlord would most likely be unless they have, like you said earlier, a breed issue or something like that, would be pretty much obligated to give you the accommodation, right?
Yes, they would, but a lot of times they don't know that. And so, again, that's where you need an advocate, because we've had these people who are just renting a single family home say no, absolutely no pets. And even when the person asks for an accommodation, they still say no. And it's just a matter of, most times it's a matter of them just not knowing the law.
Yeah, yeah. Okay, we're on the in the Q&A. So, I'm not sure, Kimberly, I understand something about they did it to you and lied 100 references and pictures, um, but they didn't renew your lease. I'm sorry, I'm not understanding your question. Maybe you're just making a comment. Um, does the landlord have to give any reason for non-renewal?
No, they don't have to give any they don't have to, they can just say they don't want to renew your lease. There's no law that requires them to tell you why they're why they're ending the lease or not renewing.
And Samson, once again, the contact information for Francis will be in the follow-up email that goes out. Would be nice if there was a public database of landlords who had bad practices and a list of their bad practices. There would be,
Yeah, that would be really helpful.
yeah,
And the issue would be,
like you could check their credit,
yeah. Yeah,
reputation.
but then the issue would be, how legal is that? Because, one person might think a property is decent and somebody else might not think
Uh,
that. Is it, how do you differentiate opinion from actual fact? You know
yeah,
what I mean?
yeah. Well, and it may be that you have to just use Yelp or one of the more the platforms that just let you give a review to somebody, right?
Mm-hmm.
Um, that's a good
Yeah, and I
question.
know I've heard of people even making complaints to Better Business Bureau about certain apartment buildings.
Yeah, yeah. I see good question in the chat, but you want to select um, the Q&A feature because it raise hands shows how to capture. I'm not sure I understand. Nicole, Nicole,
I did see some people raise their hands like
uh-huh.
while I was presenting, but I don't
Yeah, yeah,
see that
and
anymore.
there's one I'd asked them at one point if they could put it in the chat or the Q&A, but I probably should have repeated that a couple of times. Yes, the contract information will go out in the follow-up email, Mary. The Can you talk about taking asking for repairs, the tenant repairs and pay can seats? Can you talk about taking your asking for repairs and the tenant repair and pay? I'm not sure I get. I'm having a hard time with some of these. Sorry.
Oh, it's okay. I just put my email in the chat
Great.
for everybody.
Can a landlord specify in their lease before signing that the deposit is unrefundable? That's what somebody already asked that. What makes sense? Because wouldn't it be the same if the tenant stayed in the unit under the new owner? To your point, that makes sense because wouldn't it be the same if the tenant stayed in the unit under a new owner? Um, so, if lease states a security deposit is due before or at time of signing the lease, but the landlord gives the tenant the keys and collects a prorated rent, can the landlord evict for non-payment of security deposit when rent has been timely paid for 7 months? Did you
I'm not
follow
sure I
that?
understand the question.
Okay. So if the lease states a security deposit is due before or at the time of signing the lease, but the landlord gives the tenant the keys and collects a prorated rent, I guess it does not collect the security deposit before they give them the keys and pay the first month's rent. Can the landlord evict for non-payment of the security deposit when the rent? So after it sounds like after 7 months, the landlord finally
Yeah,
realized it never collected the security
yeah.
deposit.
If they have, if the security deposit is listed in your lease and you should have paid it, even if they forgot to collect it from you, if they want to be jerks about it, they can give you a non-payment. They can try to evict you for non-payment.
There you go.
And it seems really unfair, but
Yeah.
that's the way the law. I mean, so the real big, the important thing is to look at your lease document and see what it says in there, because if it says there was a security deposit and you just didn't pay it, whether or not the housing provider like legitimately forgot to collect it, if they realize it later and ask you to pay it and you don't, they can evict you for non-payment.
And I know we've discussed this, but does a late fee of 12% apply to homes as well, or just apartments?
Yeah, every rental is, it applies to every rental. Let me see if I have where's my late fee slide?
It's really bad that Spectrum is now built into the lease. My daughter barely affords rent and doesn't want cable, but can't do anything about it. Yeah, that's
Yeah, I know it's a lot of, just like I said, if you have like a trash valet fee,
yeah,
even if you don't mind taking your own trash to the dumpster, if that's in your lease, you have to pay that fee.
yeah.
I put the slide
And
back up about late fees just so people can see,
yeah,
4 units or less is 12%. So that's where your single
house,
family homes would be.
yeah. Cool. Um, can I? Someone asked if they can take repairs out of my rent, and obviously we said numerous times that is very unadvised. Not advised. We would not advise you to do that. That's a bad
Nope.
thing.
Yeah, no, don't do that, because what'll happen is you'll end up getting evicted for non-payment of rent if you don't pay your full rent every month. If you decide that you want to pay for repairs on your own, or if there's something you feel that is an emergency and just needs to be done and you've given them notice, they don't do it, you need to pay for that separately. And that's a thing that you could go to small or justice of the peace court for and ask a judge to give it back to you. In addition to filing fees and time you have to take off work, for example, all that, any kind of damages that you experience because of that, you can ask for it in court in your filing, but never take it from your rent unless you have in writing from the landlord that it's okay for you to do that.
Does a landlord have to replace a refrigerator if 6 months in it does not work anymore?
Yeah, they could also try to repair it though. They don't necessarily have to give you a new one, but that's something that you should make a repair request for and, see if they'll handle it, because you have to have, you should have a working refrigerator if that's what, was included with the apartment.
Melissa asked, and I'm assuming she's talking about the return of the keys. How do you prove that you actually return them if you don't? I'm assuming you're saying if you don't get something in writing or that kind of thing. Um,
Yeah, I mean, most times it's not a problem unless just have a bad manager of an apartment, or they're trying, or they're trying to get back at you for something. Normally you hand them the keys and, it's acknowledged that that's the date you turned them in. But like I said, you could always ask them for a written receipt, or you can, take a witness with you
yeah,
when you give them the keys. So you have that, you know what I mean?
I would note who you gave them to, when you gave them to them, and if you have somebody that can go with you and have them sign as a witness.
Yep.
If for a cat and pets are okay, if feels like they just want the deposit. It's for a cat and pets are okay.
Well,
I,
again, if
I,
it's if it's
somebody,
if it's a pet if it's a pet cat, then they can charge you a pet deposit. Is that what they're, but if it's an
yeah,
emotional service animal, then
yeah,
you have,
yeah.
you have to request an accommodation. Is that what they're asking?
I don't know. It sounds to me like they're following up on something earlier, and I didn't catch. I'm not catching the link to something. They're following up on maybe something you said, and I'm not following their train of thought there. But it has something to have to do with emotional support animal. They say it feels like the landlord just wants a deposit, but obviously some animals do damage to apartments, like pee on the carpet or whatever, and so they're wanting to cover you know themselves,
Maybe
but they can't do
if
that if it's
you
an
know
emotional
if
support animal.
if you have an emotional support animal, say it's a cat, and it causes, you can get an accommodation to not have to pay the pet deposit. But if your cat causes damage to the apartment, you're going to have to pay for that out of your security deposit, or in addition to your security deposit after you move out. So you're still going to be liable for any damage your emotional service animal causes.
And someone just asked in the Q&A, are you stating there is no requirement for an emotional support animal, no security deposit requirement for emotional support animal?
That's correct. If you have an emotional support animal prescribed by your doctor, you can ask for a reasonable accommodation to not have to pay a pet deposit
Or pet rent?
or pet rent. But again,
Or
if upon move out, you still have to pay for any damage that you or your ESA, your emotional support animal, caused. So just because they didn't collect a deposit from you doesn't mean you don't have to pay for damage if it's caused.
So there's three accommodations here. One of them is an accommodation from a no pet policy. So if they have a no pet policy, you're getting an accommodation to have a pet, even though they don't allow pets. If they charge pet rent, you're getting a pet rent accommodation because you have a pet, emotional support animal. So you should not have to pay pet rent because it is a emotional support animal. And then also the security, the additional security deposit for a pet, an accommodation to that. Is that right?
Yes.
Um, okay, so I'm just trying to go through these. Does the landlord have to update records for pet shots, etc.? Or does the landlord have to get updated records for pet shots? I guess you're saying, are they required to do that?
No, they're not required to do that, but I have heard of landlords asking for that from a tenant to make sure that the animal's vaccinated.
Yeah.
They don't have to, but sometimes they do, or they'll ask for, if you have proof that it was licensed, but you have the dog license, for example, from the city that you live in. If your city requires it, they could require that too.
And that is it. We've answered them all.
Wow. Okay.
Yeah. Francis, thank you so very much, Francis. As
Oh,
always,
you're
and
welcome.
thank you for being so generous with your time. I mean, you stayed almost an extra half hour here answering questions. Thank you so much.
Oh, of course.
Thank you all for joining us. We sincerely appreciate it. And you all have a wonderful day.
Thank you. Bye, everybody.